Rule 3117. Use of depositions, impeachment of witnesses, parties, unavailable witness. At the trial or upon the hearing of a motion or an interlocutory proceeding, any part or all of a deposition, so far as admissible under the rules of evidence, may be used in accordance with any of the following provisions. 1. Any deposition may be used by any party for the purpose of contradicting or impeaching the testimony of the deponent as a witness. 2. The deposition testimony of a party or of any person who was a party when the testimony was given, or of any person who at the time the testimony was given was an officer, director, member, employee or managing or authorized agent of a party, may be used for any purpose by any party who was adversely interested when the deposition testimony was given, or who is adversely interested when the deposition testimony is offered in evidence. 3. The deposition of any person may be used by any party for any purpose against any other party who was present or represented at the taking of the deposition, or who had a notice required under these rules, provided the court finds I. That the witness is dead, or 2. That the witness is at a greater distance than 100 miles from the place of trial or is out of the state, unless it appears that the absence of the witness was procured by the party offering the deposition. Or 3. That the witness is unable to attend or testify because of age, sickness, infirmity, or imprisonment. Or 5. That the party offering the deposition has been unable to procure the attendance of the witness by diligent efforts. Or v. Upon motion or notice, that such exceptional circumstances exist as to make its use desirable, in the interest of justice and with due regard to the importance of presenting the testimony of witnesses orally in open court. For the deposition of a person authorized to practice medicine may be used by any party without the necessity of showing unavailability or special circumstances, subject to the right of any party to move pursuant to Section 3103 to prevent abuse. B. Use of part of deposition. If only part of a deposition is read at the trial by a party, any other party may read any other part of the deposition which ought in fairness to be considered in connection with the part read. C. Substitution of parties, prior actions. Substitution of parties does not affect the right to use depositions previously taken. When an action has been brought in any court of any state or of the United States, and another action involving the same subject matter is afterward brought between the same parties or their representatives or successors in interest, all depositions taken in the former action may be used in the latter as if taken therein. D. Effect of using deposition. A party shall not be deemed to make a person his own witness for any purpose by taking his deposition. The introduction in evidence of the deposition or any part thereof for any purpose other than that of contradicting or impeaching the deponent makes the deponent the witness of the party introducing the deposition. But this shall not apply to the use of a deposition as described in paragraph 2 of subdivision A. At the trial, any party may rebut any relevant evidence contained in a deposition, whether introduced by him or by any other party. Rule 3118. Demand for redress of party or a person who possessed an assigned cause of action or defense. A party may serve on any party a written notice demanding a verified statement setting forth the post office address and residence of the party, of any specified officer or member of the party, and of any person who possessed a cause of action or defense asserted in the action which has been assigned. The demand shall be complied with within 10 days of its service. 3119. Uniform interstate depositions and discovery. Definitions. For purposes of this section, 1. Out-of-state subpoena means a subpoena issued under authority of a court of record of a state other than this state. 2. Person means an individual, corporation, business trust, estate, trust, partnership, limited liability company, association, joint venture, public corporation, government or governmental subdivision, agency or instrumentality, or any other legal or commercial entity. 3. State means a state of the United States, the District of Columbia, Puerto Rico, the United States Virgin Islands, or any territory or insular possession subject to the jurisdiction of the United States. 4. Subpoena means a document, however denominated, issued under authority of a court of record requiring a person to I. Attend and give testimony at a deposition. 2. Produce and permit inspection and copying of designated books, documents, records, electronically stored information, or tangible things in the possession, custody or control of the person. Or 3. Permit inspection of premises under the control of the person. B. Issuance of subpoena. 1. To request issuance of a subpoena under this section, a party must submit an out-of-state subpoena to the county clerk in the county in which discovery is sought to be conducted in this state. A request for the issuance of a subpoena under this section does not constitute an appearance in the courts of this state. 2. When a party submits an out-of-state subpoena to the county clerk, the clerk, in accordance with that court's procedure and subject to the provisions of Article 23 of this chapter, shall promptly issue a subpoena for service upon the person to which the out-of-state subpoena is directed. 3. A subpoena under paragraph 2 of this subdivision must I. Incorporate the terms used in the out-of-state subpoena, and 2. Contain or be accompanied by the names, addresses and telephone numbers of all counsel of record in the proceeding to which the subpoena relates and of any party not represented by counsel. 4. Notwithstanding paragraph 1 of this subdivision, if a party to an out-of-state proceeding retains an attorney licensed to practice in this state, and that attorney receives the original or a true copy of an out-of-state subpoena, the attorney may issue a subpoena under this section. C. Service of subpoena. A subpoena issued under this section must be served in compliance with sections 2302 and 2303 of this chapter. D. Deposition, production and inspection. Sections 2303, 2305, 2306, 2307, 2308 and this article apply to subpoenas issued under subdivision B of this section. E. Application to court. An application to the court for a protective order or to enforce, quash, or modify a subpoena issued under this section must comply with the rules or statutes of this state and be submitted to the court in the county in which discovery is to be conducted. F. Uniformity of application and construction. In applying and constructing this Uniform Act, consideration shall be given to the need to promote uniformity of the law with respect to its subject matter among states that enact it. Rule 3120. Discovery and production of documents and things for inspection, testing, copying or photographing. 1. After commencement of an action, any party may serve on any other party a notice or on any other person a subpoena duces tecum, I. To produce and permit the party seeking discovery, or someone acting on his or her behalf, to inspect, copy, test or photograph any designated documents or any things which are in the possession, custody or control of the party or person served, or 2. To permit entry upon designated land or other property in the possession, custody or control of the party or person served for the purpose of inspecting, measuring, surveying, sampling, testing, photographing or recording by motion pictures or otherwise the property or any specifically designated object or operation thereon. 2. The notice or subpoena duces tecum shall specify the time, which shall be not less than 20 days after service of the notice or subpoena, and the place and manner of making the inspection, copy, test or photograph, or of the entry upon the land or other property and, in the case of an inspection, copying, testing or photographing, shall set forth the items to be inspected, copied, tested or photographed by individual item or by category, and shall describe each item and category with reasonable particularity. 3. The party issuing a subpoena duces tecum as provided herein above shall at the same time serve a copy of the subpoena upon all other parties and, within 5 days of compliance therewith, in whole or in part, give to each party notice that the items produced in response thereto are available for inspection and copying, specifying the time and place thereof. 4. Nothing contained in this section shall be construed to change the requirement of section 2307 that a subpoena duces tecum to be served upon a library or a department or bureau of a municipal corporation, or of the state, or an officer thereof, requires a motion made on notice to the library, department, bureau or officer, and the adverse party, to a justice of the Supreme Court or a judge of the court in which the action is triable. 2307. Books, papers and other things of a library, department or bureau of a municipal corporation or of the state. Issuance by court. A subpoena duces tecum to be served upon a library, or a department or bureau of a municipal corporation or of the state, or an officer thereof, requiring the production of any books, papers or other things, shall be issued by a justice of the Supreme Court in the district in which the book, paper or other thing is located or by a judge of the court in which an action for which it is required is triable. Unless the court orders otherwise, a motion for such subpoena shall be made on at least 1 day's notice to the library, department, bureau or officer having custody of the book, document or other thing in the adverse party. Such subpoena must be served upon such library, or such department or bureau of such municipal corporation or of the state or an officer having custody of the book, document or other thing in the adverse party at least 24 hours before the time fixed for the production of such records, unless in the case of an emergency the court shall by order dispense with such notice otherwise required. Compliance with a subpoena duces tecum may be made by producing a full-sized legible reproduction of the item or items required to be produced certified as complete and accurate by the person in charge of such library, department or bureau, or a designee of such person, and no personal appearance to certify such item or items shall be required of such person or designee, unless the court shall order otherwise pursuant to subdivision D of Rule 2214 of this chapter. Where a stipulation would serve the same purpose as production of the book, document or other thing in the subpoena is required because the parties will not stipulate, the judge may impose terms on any party, including the cost of production of the book or document, and require such cost to be paid as an additional fee to the library, department or officer. 3121. Physical or mental examination, notice of examination. After commencement of an action in which the mental or physical condition or the blood relationship of a party, or of an agent, employee or person in the custody or under the legal control of a party, is in controversy, any party may serve notice on another party to submit to a physical, mental or blood examination by a designated physician, or to produce for such examination his agent, employee or the person in his custody or under his legal control. The notice may require duly executed and acknowledged written authorizations permitting all parties to obtain and make copies of the records of specified hospitals relating to such mental or physical condition or blood relationship. Where a party obtains a copy of a hospital record as a result of the authorization of another party, he shall deliver a duplicate of the copy to such party. A copy of the notice shall be served on the person to be examined. It shall specify the time, which shall be not less than 20 days after service of the notice, and the conditions and scope of the examination. B. Copy of report. A copy of a detailed written report of the examining physician setting out his findings and conclusions shall be delivered by the party seeking the examination to any party requesting to exchange therefore a copy of each report in his control of an examination made with respect to the mental or physical condition in controversy. Rule 3122. Objection to disclosure, inspection or examination, compliance, 1. Within 20 days of service of a notice or subpoena duces tecum under Rule 3120 or Section 3121, the party or person to whom the notice or subpoena duces tecum is directed, if that party or person objects to the disclosure, inspection or examination, shall serve a response which shall state with reasonable particularity the reasons for each objection. If objection is made to part of an item or category, the part shall be specified. The party seeking disclosure under Rule 3120 or Section 3121 may move for an order under Rule 3124 or Section 2308 with respect to any objection to, or other failure to respond to or permit inspection as requested by the notice or subpoena duces tecum, respectively, or any part thereof too. A medical provider served with a subpoena duces tecum, other than a trial subpoena issued by a court, requesting the production of a patient's medical records pursuant to this rule need not respond or object to the subpoena if the subpoena is not accompanied by a written authorization by the patient. Any subpoena served upon a medical provider requesting the medical records of a patient shall state in conspicuous bold-faced type that the records shall not be provided unless the subpoena is accompanied by a written authorization by the patient, or the court has issued the subpoena or otherwise directed the production of the documents. B. Whenever a person is required pursuant to such a notice, subpoena duces tecum or order to produce documents for inspection, and where such person withholds one or more documents that appear to be within the category of the documents required by the notice, subpoena duces tecum or order to be produced, such person shall give notice to the party seeking the production and inspection of the documents that one or more such documents are being withheld. This notice shall indicate the legal ground for withholding each such document, and shall provide the following information as to each such document. Unless the party withholding the document states that divulgence of such information would cause disclosure of the allegedly privileged information. 1. The type of document. 2. The general subject matter of the document. 3. The date of the document, and 4. Such other information as is sufficient to identify the document for a subpoena duces tecum. C. Whenever a person is required pursuant to such notice or order to produce documents for inspection, that person shall produce them as they are kept in the regular course of business or shall organize and label them to correspond to the categories in the request. D. Unless the subpoena duces tecum directs the production of original documents for inspection and copying at the place where such items are usually maintained, it shall be sufficient for the custodian or other qualified person to deliver complete and accurate copies of the items to be produced. The reasonable production expenses of a non-party witness shall be defrayed by the party seeking discovery.